Make sure that you smash that like button, share, and subscribe to our channel if you find its contents useful. And join us every Sunday from 3 p.m. to 4 p.m. for a new topic in workers' compensation. And if you have questions, give us a call. 844-984-8414. Let's get into the topic of the stream. I'm joined here with my co-host, Jorge Ibuado. This is attorney Alexander Napolin for the third episode of the Inland Empire Workers' Compensation Lawyer podcast and live stream.
And a little play on words, serious and willful, very serious topic. Topic that's not discussed too much, that employees don't know much about, and they might not recognize it when it happens. So even if they see it, they might not recognize it. So it's really important that we get to the nitty gritty, that we really explain what serious and willful is, so that if they do notice it, not only for themselves, they might have a coworker that gets hurt, and they might be able to tell that coworker, hey, listen, I think you have a serious and willful here. You know, that might help them out as well. That's covered by the Labor Code 4553. Is that correct?
Yeah, the 4553. That's the section of the Labor Code that covers serious and willful conduct by the employer.
Yeah, and just for everybody out there, it's confusing and it's not something that you have to know, but the Labor Code pretty much governs everything surrounding jobs, employment, and things that affect your life because you are an employee. So although you don't have to know it, your attorney will know it for you. That they have sections, and each section deals with a particular topic. Section 4553 deals with serious and willful, and that's what we're talking about today.
Yeah, the serious and willful misconduct of an employer that leads to a work-related injury. Or you might not yet be injured, and you're concerned that your employer is putting you in extreme danger. And you might want to know, hey, is there a serious and willful violation here? What to do about it?
Right.
If you're injured, get a lawyer.
Right.
And have the lawyer help you, like you said. But maybe you need a little more information on the topic so you can make the best decision. Maybe you want to talk to lawyers and you want to have a little more knowledge of serious and willful before you go and do that. This is a good resource here. The Inland Empire Workers' Compensation Lawyer podcasts and live streams. We have a ton of content that you can access, and today it's serious and willful misconduct. So serious and willful misconduct, it's a lot of words, but what does it basically mean? And I think that's what we want our viewers to understand right now.
Right. So it's a very technical term, and you look at the word serious, and you might think to yourself, well, I had a serious injury. Could that be serious and willful? Well, no, it's a combination, and we're going to get into it a little bit later on, but the Labor Code actually doesn't talk too much about the serious part of it. It's more about the willful part of it, right? It's all more about the conduct of the employer that caused the injury. So it being a serious injury is not the main concern here. If you have any type of injury, right, as long as it was serious and willful, then that would, the Labor Code 4553 would apply, right? So we're not talking about injuries. Maybe you were delivering pizzas, right, and you got into a bad car accident and it was serious and you got taken to the hospital and you might have had a concussion, right, or a broken arm, and it's serious, right? Is it serious and willful? Well, not yet. We have to see what happened. We have to look at the totality of the circumstances, right?
You have to look at the conduct of the employer,
right,
when you're looking at a serious and willful. Now, normally the conduct of the employer in workers' compensation isn't so much relevant.
Right.
It's a no-fault situation where you get benefits regardless of if the employer did something wrong or did something right or just didn't do something they were supposed to do, made a mistake. But with a serious and willful under Labor Code 4553, it's possible that you could get more from the workers' compensation claim because of what the employer did.
Right.
And that's the serious and willful
part of it.
It's not it's not how actually seriously injured you were.
Right.
It's whether or not the employer willfully or knowingly subjected you to a situation that could seriously injure you.
You're delivering pizzas and you get in a car accident. Well, that is a workers' compensation claim, correct? Right. You were employed. You're in the course of your employment. You got into the accident. That already is a workers' compensation claim. Now, let's say that this pizza delivery place has 5 cars, and it's known that car number 4, the brakes go out. And the employer knows, the employees know, and the employer's been told, but he has not fixed it and has allowed employees to go out and drive with that car because he says, you know what? It goes out sometimes. It's gone out 1 time, 2 times, but it doesn't go out all the time. So I don't want to go ahead and spend the money right now to fix the brakes. If that is the reason why the employee was injured in a car accident, then that could constitute a serious and willful claim, because the employer had knowledge of the brakes, and the employer had knowledge that it was his duty to fix the brakes in order to keep his employees safe. He failed to do so, and because of that, the employee was injured. Maybe not seriously, maybe not as serious as some other accidents, but he was injured, and the serious and willful portion of it is that the employer did not take care of a situation that led to an injury. Right.
It's by an employer representative. It's not just a coworker that knows of the brakes.
Right.
So it's a coworker that has no supervisory power, or what they say, the general discretionary power of direction and control, which is what's used in the code, I believe.
Right.
So the person who has knowledge within the company should be a manager or a foreman or somebody who has the ability to fix those brakes or the responsibility to fix those brakes.
Right.
If it's just Joe who you work with and you both have been complaining to each other, that's not going to be willful misconduct on part of the employer. In your hypothetical, George, you said the employer knew of the brakes.
Correct.
That is what is meant by willful. It's the willful knowledge of the safety violation.
Correct. Yeah. A lot of times we see with our clients, and especially during depositions, right? They ask them, did you report your injury to anyone? And they say, yeah, I told my friend that my back was hurting. Well, that's not reporting an injury, right? That's not the situation, but it's along the same lines. If something is wrong, if an equipment is malfunctioning, if you see something that might be dangerous to yourself or to your fellow employees, I would highly recommend that you report that to a supervisor, someone in a managerial role, or the employer if it's a smaller company, HR, anyone that has the authority to do something about it or to cause the action to take place. I would report that to. Not a coworker like you mentioned, not your family members, someone that has a supervisory role that can do something about it.
That's a really good point about the reporting.
Right.
Report, because that puts the willfulness into the employer's action or inaction. So you don't have to report it for it to be a serious and willful. But if you do report it, you're going to trigger the employer's knowledge.
Right.
And then the employer is going to have to do something about it. And if they don't and someone gets hurt, it's going to cause some penalties.
Listen, if you're an employer, you know you have certain duties, right? What are your duties? You have a duty to pay your employees. You have a duty to give them breaks. You have a duty to make sure that their environment is safe. And there's some government agencies, entities that take care of some of that for us, right? Like OSHA. There's a bar. The bar is set, and if you perform under that bar, you get citations. Now, listen, once again, we'll go in parts, but if you have an employer who has an OSHA citation violation, that is a great way to get a serious and willful claim, to win a serious and willful claim. Right. I mean, that's one way to win it. But an employer has a right to provide these things for their employees. If they're not doing that, then the WCAB, Workers' Compensation Appeal Board, through Labor Code 4553, is going to come and tell them, you failed miserably. You failed your duty to your employees, your responsibility, and because of that, we're going to penalize you. Although it doesn't say the word penalize, doesn't say the word punitive, we're going to penalize you, and you're going to pay 50% of whatever you have already paid, and you will pay for this. So we're going to get into that. What does that mean? They pay 50%.
Yeah, so normally you get a standard set of benefits under workers' compensation law. But if you can prove that the employer acted willfully, it's a serious and willful, and it caused your injury, then you get that 50% increase in your compensation rate.
Right.
Which is an increase in all of the compensation that you ever collect under the claim times 50%. You get that additional money.
Right.
Which is pretty amazing.
It is amazing. That's a good value for someone. I mean, Alex, we're not talking about 50% of your PD, your permanent disability, right? We're not talking about 50% of your CNR. We're talking about 50% of all the benefits received. What are some of the benefits that a workers' compensation injured worker can receive?
Like permanent disability, like you mentioned.
Right.
So at the end of the claim, if you have a permanent injury, if you have something that's going to permanently limit your earning capacity. And it is you don't get a life pension,
correct,
unless you have a lot of problems in workers' comp. And that's why the serious and willful helps you so much.
Right.
Because benefits are limited.
They're limited.
You only get, like you mentioned, maybe 15%, maybe $17,000 in permanent impairment for an injury that you perceive as very serious.
Correct.
And limits your ability to work.
Correct.
Because workers' compensation benefits are limited.
Right. That's a very good point. And so the permanent disability is not the only benefit you get when you're an injured worker. And I do want to make this quick point. I do have clients that when we reach the stage of settlement and the doctor has given, and we've gone through a lot of doctors, and maybe we've seen a neutral doctor, and the doctor provides a permanent disability, and they might not think it's fair. But you have to understand the way these doctors come up with their ratings. They have to follow the AMA guidelines. They have to use a chart. They have to use tests. They have to use range of motion. So it's not something that's very arbitrary. They do have some latitude, correct? Alvarez Guzman, but it's very, very precise. So if you don't feel that your injury is if you feel it's more serious than what the doctor is saying, then there's not much recourse, because unlike a case, personal injury, where you have, or a civil case where you have pain and suffering, loss of, what would be something else that you can think of?
You have loss of consortium with your spouse.
Correct, yeah.
Loss of life's enjoyment, they call it.
There
Trauma.
you go.
Just the experience of having a traumatic event in your life could get you more compensation.
Right. So but
you don't have that on workers' comp.
You don't have that in workers' comp, and people want that in workers' comp. Yeah. So they have to understand we cannot, it's not that we're not, we cannot fight for your pain and suffering. Now, there's a psych component to it, which is different, but pain and suffering alone, you can't get money for.
Right. Like if you develop a psychological condition from a trauma, then it's diagnosed by a psychologist or a psychiatrist, and you're given a prescription, and it's said to be work-related, then you might get some benefits for having the psychiatric disorder. But that's not pain and suffering. Pain and suffering is it's a concept of damages in civil law that does not apply to workers' compensation injuries. We don't even look at the defendant's or the employer's conduct generally when it comes to work-related injuries.
Right.
So pain and suffering exists where someone hurts you negligently.
Correct.
But employers are exempt from those laws.
Usually,
unless they don't have workers' compensation insurance.
Or unless it's a serious and willful.
And if it's a serious and willful, you get these additional benefits, which could be more than the pain and suffering on a civil claim.
For their conduct that they did willingly, or something they ignored that they knew would be very dangerous to their employees. So the employer is brought in. So we'll finish up right now talking about how much more money you can get, because we started talking about permanent disability. That's a value. Then you have temporary disability, which you get paid while you're not working. That has value. But something that our viewers might not even have a clue as to what they might get is you also get half of whatever the insurance company paid for your medical treatment. That includes medical treatment. That includes your primary treating physician, any specialist you might have seen, any MRIs, any testing that was done, any panel qualified medical examiner, the neutral doctor, any medical expenses are in there as well. So we got medical expenses, temporary disability, permanent disability, and voucher.
And mileage reimbursement.
That's very small, and actually a lot of people forget about mileage reimbursement, but you got to remember. So
if you can prove that the employer committed a serious and willful violation under 4553, then you get a 50% increase in all of those benefits. It's important, I think what you're pointing out is that some of those benefits aren't money benefits. They're benefits that you get because you were injured and you needed medical care.
Right.
So the insurance company paid a doctor, let's say $25,000 to do your surgery. That you get a 50% of that.
Right.
So it's everything. Yeah. It can be quite substantial.
Now imagine, Alex, what if it's not just surgery? What if it's surgery and prosthetics? Right. So now all the money spent on prosthetics, on surgery, on aftercare, if it was a really bad surgery, all that money you're getting 50% of on top of what your payout would have been if it wouldn't have been a serious and willful.
Yes, and you have to prove that the employer engaged in serious and willful misconduct, which is a significant burden because you have to prove basically the mental state of a representative of the company that was in control, that had general discretionary control of the equipment or the site where the violation occurred.
Right.
So if you can't prove that, which it can be hard, then you're stuck with a regular workers' comp claim. And that's why it's important to contact a lawyer as soon after a work-related incident as possible, because these claims need to be investigated. The other way you can prove the serious and willful, as you were mentioning, though, is the violation of a safety order.
Correct.
Like you were mentioning OSHA and other government agencies that issue citations.
Right.
When the government entity issues a citation, now you might be able to bypass that proving the willful mindset of an employer and just say, hey, you had constructive knowledge of that safety violation. Yep. You should have known the rules, and the law actually imputes that knowledge to the employer. So that's another way. If you have an OSHA violation or there's some other, it could be a city citation from a city or some other place.
It can't be a citation from your uncle just going to the workplace and telling them.
Can't give you a red card.
Well, actually, it might. If he put them on notice that something was wrong, it actually could work. It was supposed to be a joke, but hey.
So it's more than just mere negligence.
Yeah.
These serious and willful claims, and it's important. Like I was reading some case law, and like for example, if there's a drippy faucet or something that's known and it creates a puddle, and someone slips and fall on that puddle, that's not necessarily a serious and willful, even if the employer willfully did not fix the dripping sink or faucet or pipe or whatever it is. There's another case where there was some carpet that was frayed and someone tripped and fell on the carpet, and the employer knew that the carpet needed to be replaced. The Workers' Compensation Appeals Board found that that was not a serious and willful, despite the fact that the employer knew about the safety problem.
Right.
Because the employer did not have reckless disregard for the employee's safety, because the employer didn't really have knowledge of the seriousness that could result.
Okay. But what about one of those guards that guards the blade going around when you're cutting wood and there's no guard in place?
Right.
That's a lot more serious than some frayed carpet, correct?
Yeah, there's a distinction right there.
Right.
You have an inherently or obviously dangerous piece of equipment. Frayed carpet or a leaky pipe, those things happen in our ordinary life every single day. You wouldn't say because that exists that someone's going to lose their hand.
Right.
But if somebody doesn't have a guardrail on a machine, or if there's not, like you mentioned earlier, safety equipment when cleaning buildings, windows, or doing construction on a high rise, and there's serious injury that results, it's going to result in a safety violation that's probably serious and willful.
Definitely. And I do want to point out that we talked about the value of your possible serious and willful, and we'll give an example right now so you can actually see how it would work. But one thing that's really interesting, Alex, is that this is a statutory violation. Now, what that means is that the judge has no discretion, absolutely no discretion in how much he's going to award. Okay, this is an all or nothing. It's a go big or go home. You either get 100% of that 50%, so 100% of the award that you're going for, or you get zero. So either you can prove that it was a serious and willful, or you don't prove it was a serious and willful. It's not a, hey, it was kind of serious, we'll give you this much money. No, the judge has no discretion about that. He either says it was serious and willful or it was not.
That's a really good point. The code says that the judge shall order the 50% if the applicant proves that the employer screwed up and knew about it.
And shall is a very important word, as we learn in law school. Shall means he shall, he will. It must be done.
You shall pay.
You shall pay.
The law says no discretion by the judge, which I think is really, in a jury trial for, just general damages like pain and suffering, you have to prove the value of the pain and suffering. Yeah. That's a whole nother game with the jury. That you have to play. You don't play that with the workers' comp judge. Mm-mm. You prove the serious and willful violation, you get the 50% increase.
Right. And as you said, it's not a jury trial. It's the workers' compensation judge. And the reason this is so important and the reason I like this is because Workers' compensation judges usually do not deal with serious and willful. This is not very, very common. It's very common for an employee to get hurt. Our workers' compensation system is plagued with people that have hurt themselves, anywhere from slightly serious, an ankle sprain, or maybe a broken finger, to really serious, maybe something that might need an operation, like a back operation, spine operation. So, you have levels, right? But for it to reach serious and willful, it's not extremely common. So the workers' compensation judges don't see this very often. And the reason this is good for the injured worker is because we live in a very good state for the injured worker. California is, in my opinion, one of the, if not the most favorable state for the injured worker. These workers' compensation judges, in my opinion, go above and beyond to make sure that the injured worker gets their benefits and the benefits that they deserve. So if the scale is going to kind of teeter-totter whether or not it was serious and willful, and it could be, but it could not be, sometimes, and I would venture to say more often than not, a judge is going to say, you know what, give it to the injured worker and let the employer learn their lesson. Maybe they'll be more careful next time, and there won't be more injured workers like that.
That's a good point. There's the rule of liberal construction in favor of extending benefits to the injured worker.
Right.
It's almost a tie goes to the injured worker.
Right.
If you're at a 50-50, injured worker gets it.
I like that.
That's not true in other areas of law.
No.
Where the plaintiff in a personal injury action has the full burden.
Correct.
But, in terms of serious and willful, you have to prove the employer's mindset or the safety violation. Right. So you got to come up with something. You can't just be your word.
Right. And like you mentioned, here the employee is the one that has to prove the serious and willful, right? So you have to prove it up. But like we said, there's several ways to do it, and it's best if you talk to
right away.
It's best if you talk to an attorney. No, it's good if you talk to an attorney. It's better if you talk to a workers' compensation attorney. That's right. And it's best if you talk to the injury pros.
That's correct.
Right? So
we understand the topic. We've done the serious and willful claims before, and we know what we're looking for. You got to come in as early as possible because there's only 12 months to file the serious and willful claim.
12 months or a year?
The statute says 12 months.
Okay.
Interestingly.
Yeah.
And that is and I don't know if that's different than 1 year, but it could be.
If it's leap year.
What if it's a leap year and it's 12 months? How does it
and I know we're joking around a little bit, but the funny part is that I do want to say this. A lot of there's statutory limitations for bringing on a claim, right? Just as with any area of law. But with workers' compensation, those tend to bend a little. Am I correct? Would you agree?
There's a lot of exceptions and nuances to the statute of limitations when it comes to workers' comp. There's lots of things that can extend it.
Right.
Not much I don't think there's anything that can shorten it.
No, I don't think. Well, I want to talk about the negligence standard because Labor Code 4553 is very clear that the negligence standard is a little bit broad. Negligent could be a lot of things, right? We're negligent every day, I think. Most people are negligent in a lot of tasks they do because we're in a hurry. But this this negligence standard is very broad. I think that Labor Code 4553 makes it much more narrow. And instead of just a negligence standard, it actually says it requires something much more than negligence. Yes. And what does it require? Intentional knowledge of wrongdoing or by the employer, company, or organization, or extreme disregard for employee safety. Yes. Now that's pretty harsh, no? I mean, I would imagine that's a high bar to cross over to prove.
But probably not as uncommon as you think. Maybe uncommon to be able to prove it. Mm-hmm. But like you said, people are negligent every day. And when it gets between an employer's money and, the end of the month, maybe safety goes out the window and they make a decision to disregard someone's safety because they have something better to do or they don't want to spend the money to correct the issue.
Which is funny because of their disregard and because of their carelessness, now they're paying money out of pocket. Because as you know, insurance companies do not cover serious and willful. Can you talk a little bit about that?
Right. So serious and willful is not covered by the insurance carrier.
Yeah.
They'll pay, Go ahead.
Or any other third party. They actually can't even shift their liability to anyone else. It's the employer. It's coming out of their pockets. They're paying you for their negligence, their severe, extreme negligence, or inaction to keep you safe.
That's right. They're going to have to pay you out of pocket, no insurance carrier money available. So expect to have another lawyer on the other side when you sue for serious and willful, because they're going to bring in their own attorney that's probably going to represent them. You also get $250 additional for the costs of suit for a serious and willful. If you prove a serious and willful, you get an additional $250 for costs, which I presume is to, do some type of additional investigation or whatnot. I mean, probably it's important to take a deposition of the employer. If you have a serious and willful and you think you have it, you want to take the deposition of the employer, maybe the $250 helps you with some fees there.
Yeah, and then deposition is important because when you're under oath, if you lie, you're subject to perjury. Now, an employee, if they lie under while they're under oath in their deposition, then they could be subject to perjury and fraud, right? Because fraud is any type of lie, either under oath, not under oath, when you lie to try to obtain workers' compensation benefits.
That's insurance fraud.
Correct.
Perjury is just lying under oath.
Correct. But my point was that if we get an employer and we subject him to a deposition, and under oath, he states that he had no knowledge, he's completely clean, it was an accident, and he had no knowledge of this dangerous situation, but then we find out that he did, now he's subject to perjury.
Oh, yeah.
So he's going to be much more willing to tell the truth under oath during a deposition than just asking him, right?
Absolutely.
Yeah.
If something is so obvious, let's say the employer is walking by and sees that there's no guardrail on there,
right?
And then later says in their deposition, well, I wasn't aware of that. I didn't see that. Yeah, but it was right there. You looked at it.
Yeah.
And you didn't see it. Well, the obvious nature of it could impute the knowledge, because no reasonable person would not have seen that or understood it. So, that or misunderstood it for that matter.
Right.
And that's discussed in the case law as well.
Right. So it's more of a reasonable person standard as well, right? I mean, that comes into play. Any reasonable person would have seen that guardrail and said, hey, there should probably be a guardrail right there, or else someone's going to get really hurt.
Yeah, I mean, if it's obvious, if it's an obvious hazard, the employer isn't going to be able to get out of it by just claiming willful ignorance.
Right.
Well, I just buried my head in the sand and I never went over to that part of the yard, so I never looked over there and therefore I didn't know.
Right.
Well, that's not necessarily going to get you out of it. Ignoring that area of the business could be the willfulness that resulted in the serious injury, like the not doing something.
Right. And I think that brings us to an important part of law that applies to a lot of different situations, where they say, I know you've heard it, but I don't know if our viewers have heard it, where they knew or should have known, right? Maybe you didn't know, but you should have known. Right.
You should know of safety standards and safety rules as an employer doing business in California. Like if you're a construction company, you're charged with knowledge of all of the safety rules. You can't just say, well, I didn't know about that safety rule. That's imputed to you.
Right.
So there are things that the employer can be cited for, like you said, and then that can result in a violation of serious and willful.
Right.
So there is that aspect of it where, yes, the employer has to have the intention, but maybe it's the lack of intention to do something that they're obligated to do that results in the serious injury that results in a serious and willful violation.
Right. And then just to finish off this segment, California courts has said that the California Supreme Court said employer commits willful misconduct when they turn their mind to the fact that the injury to their employees will probably result from their acts or omissions, but nevertheless fails to take appropriate precautions for their safety. So that's pretty much in a nutshell, right? What we've been talking about.
That's the definition right there.
So you're looking at your situation. You believe you have a serious and willful. You go to an attorney, to the injury pros, and we confirm it. We say, we think that you definitely have a serious and willful action here. Now, as a team, how do we prove it? How do we as attorneys, or even if you're representing yourself, which I do not recommend, but if you're representing yourself or as attorneys, how do we prove a serious and willful?
Well, you're definitely going to want to be looking for other witnesses that are willing to testify on your behalf, which could be difficult. It's one way you could prove it.
Why is it difficult? I mean,
well,
I know
other
why.
Employees might not want to testify against their employer.
Right.
And this often happens in all types of employment actions. So it can be hard if you say you reported it, but it was your coworker who witnessed you reporting it, and the foreman or manager or employer representative is denying it, or they're going to deny it. It's an issue. So getting a lawyer early to tackle that down and maybe get a witness on your side is important.
Very important. In order to prove the serious and willful, you have to either
yes,
prove that the employer failed to act even though it had information or knowledge that a serious injury would probably result, or that the employer violated one of the California safety regulations even if no citations was issued by OSHA.
Right. Okay.
So those are two very good ways to prove it. Okay. We can come up with other ways, but generally those are the two main ways to prove a serious and willful.
So yes, and I've done the petitions before, and one of the things is you find that violation. Even if OSHA didn't cite them for the violation, you find that violation and you put it into a separate pleading that you lodge with the Workers' Compensation Appeals Board within 12 months or 1 year of the actual injury date. If you miss the 1 year, even if they provided you with the benefits on the underlying claim, even if the employer sent you to the doctor and provided you temporary disability, you still only have 12 months to file the serious and willful petition with the Workers' Comp Board.
Now, once you file a serious and willful petition, does that toll the statute of limitations? In other words, can you proceed with your claim, get all your treatment and everything, and then not really handle that for a while until your claim is over and then proceed? Or do you have a year, you file, you work it up, and you have to proceed with it at the same time that you're handling your workers' compensation claim?
Right. Well, you're not going to be able to know the full damages that the serious and willful might bring you because it's a 50% increase in the total compensation. So you won't know the total amount that you will receive until the end. And you won't prove it until the end because you're going to need a judge to say this is a serious and willful violation. So it will go along with your workers' comp claim. It has to be filed within 1 year, but your workers' comp claim could take years. Right. And it can go along with that claim, and then eventually there will be a trial, and the judge you'll have the opportunity to present it to the judge, and then the judge will make a findings and award based upon hopefully the serious and willful violation if you have it. Yeah. But I don't think there's any time frame after that. Once you file it, you're good forever. Okay. Which is great about the Workers' Comp Board.
I love the Workers' Comp Board. It's really good to employees.
And like you were saying about statutes, if you had an injury years ago, you shouldn't let that discourage you from getting a workers' comp lawyer.
That was my point, yeah.
There's a lot of people that go online and they're like, oh man, I only had 1 year. But wait a second, did they give you a claim form? Did you report it? Did they give you treatment?
And a little secret, even if they didn't do all that, or if they did all that, you could probably still file a claim.
Yeah, you could probably still file a claim.
Right.
Yeah. Because, especially if you work somewhere for a long time and it's a cumulative trauma claim, certain employees are going to, you just can't deny that the injury arose out of it in the course of employment, especially if you get a QME that says it. Especially because all those injuries too, those statute of limitations, I don't know if it's for post-termination claims though.
Not sure.
The statute of limitations on a CT claim can be when they first had knowledge of the disability and experienced it. Right. But for statute of limitations, it doesn't matter.
And listen, I tell my clients all the time, it's not for you to decide if it's an industrial injury, if it's a work-related injury. What I want to know from you is, do you have pain? Do you have pain in your body and different body parts? And do you think it's work-related? If you do, both things, then we're going to go to a doctor, and the doctor's going to give his professional opinion on whether the work you did or your job or job situation caused those injuries. That's not your job to prove. It's the doctor's. Technically it is, but through doctors. We're going to get doctors' recommendations, doctors' expert opinions. And once we have that, then we can go ahead and say it's work related or it's not work related, or we can keep on fighting the issue. But you're not the one that has to prove to the judge that you did get hurt at work.
Okay, so just wrapping up the serious and willful business. You get workers' compensation benefits if you're hurt at work.
Right.
And your employer has workers' compensation insurance.
Right.
And those are some basic benefits, and we went over those earlier in the episode.
Correct.
And the main thrust of the episode is if you have a serious injury or any injury at all, and you believe that it's from the willful misconduct of your employer, then you need to consult with a workers' compensation lawyer right away.
I like that.
Or if you have an injury at all.
Yeah. Just one thing.
Your back hurts.
Yeah. Just one thing is very important to point out. We said it, but I hope the people out there caught it. Action or inaction. So whether your employer did something that hurt you or caused your injury, or whether they did not do something and because of their inaction, you got hurt.
Strongly encourage anyone who's hurt at work to consult with a workers' compensation lawyer.
Yeah.
Particularly my co-host, Jorge Ibuado, who is an excellent litigator and just eats employers for lunch.
And I'm hungry.
And he's hungry.
So a little parting thoughts. California judges don't see these cases very often, or as often as you would think. So they're very sympathetic to the employee. So if your attorney, and it's a good attorney, believes you have a serious and willful, first you can spot it out. After watching this episode, you can say, hey, I think this might be a serious and willful. You consult us or an attorney, and they believe you have a serious and willful, then that's good for you, because once again, judges are very sympathetic to the employee, and they don't see these cases very often. So they don't see these cases very often, sympathetic to the employees, and it could be a substantial increase in the benefits that you obtain overall.
Yes, and it's important to find the right lawyer who will review the situation and make that decision early on if it's going to be pursued as a serious and willful. Because a lot of lawyers, they'll just look at it and they'll just treat it like every other claim.
Right.
Every claim gets benefits if it's accepted because it happened at work. It gets the same benefits. We fight for those benefits. So if you have a serious and willful, make sure you contact a lawyer who understands serious and willful, which, of course, is the Inland Empire Workers' Compensation Lawyer live stream and podcast hosts, Alexander Napolin and Jorge Ibuado.
So I think we had a great episode today, Alex. I think that the information that we talked about can be really helpful. Yeah. So that's what makes me really happy, being able to help the people out there and give you information. They always say knowledge is power. And the thing is that these huge insurance companies, they have a lot of power. Because they can afford it, right? They can hire these attorneys, they can hire large firms. But what we want to do is bring this power to the injured workers. So that's why we're here. So I think we had a great episode. Thank you for being with us. This is Attorney Jorge Ibuado, Attorney Alex Napolin, and
we'll see you next week for episode 4 of the Inland Empire Workers' Compensation Lawyer live stream and podcast.
Awesome. Thank you.